Will those in the gallery please be seated? And please keep the aisles and doors clear for safety reasons. The joint session will now come to order. Senate Majority Leader Fenberg.
Thank you, Madam Speaker. Members, I move that the morning roll call of the Senate be made the Senate roll call of the joint session.
If there's no objection, the morning roll call of the Senate will be made the Senate roll call for the joint session. House Majority Leader Garnett.
Thank you, Madam Speaker. Members, I move that the morning roll call of the House be made the House roll call of the joint session.
If there's no objection, the morning roll call of the House will be made the House roll call for the joint session. A quorum is present. As is customary, it is my privilege and honor to present the gavel to the President of the Senate with the request that he preside over the proceedings.
Thank you, Madam Speaker. Will the Joint Committee composed of Senators Todd, Gardner, and Representatives Wiseman, Gonzalez, Gutierrez, and Carver please escort the Chief Justice to the House chamber? Chief Sergeant of the House, Hudson.
Mr. President, Madam Speaker, ladies and gentlemen, please rise for the Chief Justice of the great state of Colorado, the Honorable Nathan B. Coates.
Will the escort committee please proceed to the podium? Members, it is my pleasure and honor to present to you the Honorable Nathan B. Coates, Chief Justice of the State of Colorado.
Thank you. Please be seated. Madam Speaker Becker, Senate President Garcia, distinguished members of the Senate and House of Representatives, my thanks for your generous invitation for a coordinate branch of the government to address you in this chamber. I think this has become a very worthwhile and meaningful tradition, and I'd like to express both the appreciation of the judicial branch and also my personal hope that the tradition continues long into the future. Let me begin by introducing my fellow justices who've also come to represent the branch today. Although we make all of our important decisions en banc, as we say, or all as a whole court, after the Chief Justice, we measure seniority by the length of time you've been on the court. So in order of seniority then, let me introduce my colleagues. First, Justice Monica Marquez. Justice Brian Boatwright. Justice Will Hood. Justice Rich Gabriel. And since we last appeared in this chamber to do one of these addresses, our newest justices, Justice Melissa Hart and Justice Carlos Samor. I'd also like to introduce the State Court Administrator, Chris Ryan, whom I've asked to come and sit with us today. And finally, I'm pleased to introduce my wife, who's here, Dean Emerita of the Sturm College of Law at DU, Mary Ricketson. And my daughter, who's currently a Deputy District Attorney at my old office in Denver, Joanna Coates. I've been kind of intrigued over the years at how many lawyers don't even really understand how our court works or how the judicial department is organized. So I'm going to lead you on a little path here through just some basic things to get us started and then get into the more specific things I wanted to talk to you about. But first, the Chief Justice of the Supreme Court in this jurisdiction actually wears two very distinctly different hats. Although the Chief has an important leadership role, pretty obviously, in the organization and conduct of the business of the court, the position of Chief, really could probably best be described as first among equals. The Chief has an equal vote, but no more than an equal vote with the rest of the members of the court. And unlike the United States Supreme Court, where the Chief Justice is, as you know, nominated by the President and confirmed by the Senate into a specific slot or a specific line as Chief Justice, that's not true in Colorado. In Colorado, the Chief Justice is selected by and serves at the pleasure of the rest of the court. But in addition, and this is probably the part that will have most affect us here, Article 6, Section 5 of the state constitution specifies that the Chief Justice selected by the majority shall be the executive head of the judicial system of the state. And it's in that capacity that, as the Chief Executive Officer of the judicial branch, that I'm addressing you today. In thanking you for the invitation to speak, I referred to us as coordinate branches. Let me take just a second and explain what I understand to be the coordinate nature of our relationship. Although we're very expressly and purposefully organized in the Constitution as separate co-equal branches of government, we're not only co-equal branches, but in fact we share what might be described as a symbiotic or cooperative relationship. In a very important sense, each of us depends on the other. The roles assigned to each of us, although different, are necessarily cooperative, both being essential to the fulfillment of the core functions of government. As limited by the Constitution, the fundamental law from which each of us derives our powers and authority, and apart from that portion of the legislative power that you have willingly delegated to the executive in the form of the administration, this body is clearly the lawgiver with regard to matters concerning governance of the state. You indisputably set policy for the state and enact that policy into governing law to be carried out and enforced by the executive branch. The power of the judiciary, on the other hand, is largely limited, except for supervising its own operations and the practice of law in the state, to making judgments about the nature and effect of policy choices that have already been made by others. And with regard to the laws enacted by you, our role in the system is limited to determining what you meant in enacting those laws, how you intended them to apply in individual cases, and that they don't conflict with the fundamental law or Constitution. Similarly, though, where you've left it to others to arrange their own affairs, whether by contract, lease, will, or any other legally enforceable arrangement, it's the role of the judiciary to determine what those parties intended. The core function of the judiciary, then, is to provide appropriate forums, a fair process, and neutral and impartial decision makers, school at interpreting the law according to well-established principles, which permits your constituents to resolve their grievances and order their important affairs with the force of law. Included in your function, the legislative function, is, of course, both the power and the duty to raise and allocate resources necessary for the functioning of state government, and that's without regard to which branch is exercising the governmental power. So both the executive and judicial branches are dependent upon you for the resources required to fulfill their constitutional obligations. It's therefore for both natural and proper for us to regularly report to you how we're fulfilling those obligations and to offer our professional assessment of the resources we need in order to continue doing so. Although I'm now well into my 19th year serving as a justice on the Supreme Court, my hair was actually white when I came to the court. It didn't turn. And I've actually been more than 40 years now participating in the work of the court, either as an advocate or a close court watcher or serving on their boards and committees and other organs. I actually measure my time as chief only in months. I want to point out, though, that I'm quite proud of the accomplishments of the branch that I've now the honor to lead. And with your indulgence, what I would like to do is kind of give you a brief overview of what I'm finding about the department now that I'm the chief. As you might well imagine, over the 40 years I've served the judicial branch, it has grown along with the state whose people it serves. We now have 64 counties in the state, the last being Broomfield, which was created just over 20 years ago. For about the last half century, the counties of the state have been organized into 22 judicial districts. Just to remind you, the district courts are the trial courts of what we call general jurisdiction. That means they can do civil and criminal cases of all kinds throughout the state, where the county courts are limited jurisdiction, usually limited to the less serious criminal offenses, misdemeanors, and certain civil cases where lesser amounts are in controversy. Each county and judicial district has to have at least one judge, but of course, in light of growing populations and case filings, the vast majority have many more. Counting some 40 magistrates who are authorized to perform only limited judicial duties, along with the county and district court judges, the total number of judicial officers in the state now approaches 400. In 1969, this legislative body created an intermediate appellate court, the Court of Appeals. At that time, the Court of Appeals was comprised of only 7 judges, and they had limited authority to help deal with the burgeoning backlog of trial court judgments that were awaiting some kind of appellate review. Since that time, you've continuously expanded the review, expanded the authority of the Court of Appeals to include review of almost everything except a very select few kinds of cases. Like many of you probably know, cases involving water rights go directly to the Supreme Court. There are a few examples like that. But you've expanded it in this way in order to keep pace with the ever-increasing demand. And by the way, you've also expanded the number of judges. The Court of Appeals now consists of 22 judges instead of 7. But the ultimate legal authority with regard to matters of state law rests with the 7-member state Supreme Court. In one form or another, the Supreme Court has authority over virtually every kind of legal dispute that can happen in the state, and also over the lower courts of the state, and also over the practice of law in the state. And while the Court of Appeals has become really the workhorse of appellate review of the district court judgments, now resolving, the latest figures I get are about 2,300 appeals a year. The Colorado Supreme Court, like the United States Supreme Court, has become largely a court of discretionary review, which means for the most part, we get to choose the cases that we'll decide. And we do that on the basis of how important we think they are and just how broadly the impact of our decisions resolving them will be on lots of other cases. And while the Colorado Supreme Court, like the United States Supreme Court and the federal system, therefore fully resolves by published opinion a lot fewer cases than the Court of Appeals, it nevertheless has to evaluate in substantial detail some 1,100 petitions for review every year just to decide which ones are the important ones that we want to select and fully decide. And then we go on and decide those cases and publish the results. But let me say, in addition to this 1969 creation of the modern Court of Appeals, there were several other initiatives that took effect roughly about the same time that radically altered the nature of the judiciary in this state and actually its relationship to the legislature. And I'm going to mention a couple of these that I think are critical to understanding the current state of the branch. With regard to the method of selecting state judges, first, and by selecting, then that determines the very nature and makeup of the judging profession in this state. An amendment to the state constitution was passed in 1966, you may remember, that created a kind of a merit selection system for judges, which was really quite a great departure from what had existed before. So in this system, applications for judicial openings are reviewed by independent commissions in each of the judicial districts, or by a separate state commission for the appellate courts. And the members of the nominating commissions are chosen according to a constitutionally established formula to include both lawyers and non-lawyers and a balance of political affiliation. Each nominating commission is chaired by a justice of the Supreme Court who serves as a non-voting member. And then the ultimate selection of judges by the governor is limited to only 2 or sometimes 3 qualified applicants that are forwarded to the governor by the appropriate commission. While perhaps no system of selection involving human beings can be entirely objective, and our system was clearly designed to account for very diverse views in the community concerning what the proper credentials for being a judge should be. I want to say that after chairing commissions all over the state for almost 20 years now, and that has carried me to some of the most extreme parts of the state. I have to say it's been like a tour here, going on tour. So I've done very many of these. Actually, I've done commissions that have sent names to the governor for now about 75 different judgeships over the time. And having done all of those commissions and seen them in the various parts of the state, from the most metropolis to the most rural, I can truthfully say I have never witnessed overtly partisan, in the sense of party politics, to be a factor in the judicial selection. And since the adoption of our merit system, more and more scholars, and you've probably read this, and judges, political figures throughout the country tout the kind of system we have, and more states have been adopting it all along. But in addition to the makeup of the judiciary of the state, the organization and funding of the judicial branch also underwent a really big change right about the same time period. In 1970, after years of debate, this body, the General Assembly, pretty much assumed the role of funding the state judicial system, a part that is from the courthouses themselves, which I'll talk about a little bit more. But in particular, the statewide funding funded a central support mechanism to assist the Supreme Court in administering the judicial system. And in commenting on the value of this centralized system of state financing just a couple of years later, former Chief Justice Pringle was quoted as saying, "State funding makes it possible to budget on a system-wide basis makes it possible to shift personnel as well as judges on a temporary basis when workloads require, permits economies of scale, facilitates the overall development of a management information system, makes it possible to meet unusual emergencies, and makes greater operational efficiency possible through control of resources and the development of cost and caseload data that show meaningful comparisons among the courts and among different kinds of cases. To satisfy the vast array of legal needs of the people of the state and the need to fairly and appropriately resolve their grievances, the branch now operates 410 courtrooms throughout the state. And while the responsibility for financing the physical structures housing those courtrooms remains with individual counties, for nearly the last half century, it has therefore been the statutory responsibility of the state to furnish those courtrooms and to fund judges and necessary supporting staff. That, by the way, now accounts for some 3,800 full-time equivalent positions in the branch, with a budget in the neighborhood of $600 million. Although the individual counties remain responsible for providing courthouses for their own county and district courts, since 2014, you have assisted with the construction and remodeling of court facilities in areas of the state that are basically just incapable of doing it by themselves. In that regard, allow me to say a word of thanks to you, but also a word of praise for the joint efforts of the judicial and county officials in the 12th Judicial District in bringing online just in September a much-needed modern courthouse in Alamosa, which now houses not just the county court there, but 4 district court courtrooms. Supplemental funds from the state were fundamental in finding a solution for that facility. But similarly, assistance from the state through the Underfunded Facilities Fund is making possible a new courthouse to replace the 1904 facility in Walsenburg. Those of you that have been around long enough may recall the dire condition of that courthouse that my predecessor, Chief Justice Nancy Rice, described in rather colorful terms in this chamber a few years ago. But the vote has been approved this last election, and the plans are in the works right now for building a new courthouse. Through efficiencies involving computer and other technological advances, as well as centralization of a host of administrative and support functions, we've managed to free up judicial officers from many of the side or collateral, but nevertheless very time-consuming tasks that used to divert them from their core function, which is sitting in judgment of actual cases and controversies. But you know, at some point, no matter how much you can do in terms of efficiencies, you just need more well-trained and impartial judges. And that fact just really can't be got around. To assist in the rational allocation of scarce resources among competing interests, we have, for more than the last 20 years now, measured need for judicial officers much more precisely than we used to in the old days with kind of general metrics like population growth or general changes in court filings. And by collecting data on the time actually spent on particular duties and particular classes or kinds of cases, we've been able to provide you with figures in the form of empirical weighted caseload studies that more precisely demonstrate this demand. And by the way, which you have relied on over the last 20 years a number of times to approve more judges that are needed in the jurisdiction. Just as some examples, since 1920, you have credited our calculations to increase judges statewide a number of general times, but very specifically in 2001, for example, You all approved an increase of 25 district court judges. And again, in 2007, you approved 32 district court judges to meet what then was the burgeoning demand. We generally haven't made these requests until the demand is really beyond dispute, and we have not made a large request like this since 2007. Using this system of measurement that I'm talking about that you've credited in the past, the branch is now prepared to represent to you that we are currently operating at about 77% of the district court judges actually needed in the state. I'm happy to report that I understand a bill has already been introduced in the Senate to increase the number of district court judgeships by 15, precisely allocated throughout the state according to greatest need, and that would have the effect of bringing that 77% figure up to about 82% of actual demand. While it doesn't completely offset the existing need, members of both of our branches have looked at this and consider that this figure is both realistic and sufficient to prevent shortages in the immediate term. At this time, may I offer my special thanks to Senators Lee and Gardner and Representatives Herod and Carver for sponsoring this much-needed measure. The need for more decision makers is really being driven from two different directions. The first one's pretty easily measured, and that's just the jump in felony case filings throughout the state in recent years. The second one I'll mention briefly is a little more subtle, and that has more to do with the expanding role of the judicial branch alongside the legislative and executive branches in addressing the broader societal problems giving rise to this increasing need for legal services. With regard to the first, for various reasons which may be subject to some debate, felony filings in the state in the last 5 years have climbed by more than 40%. Our data indicate that this trend is statewide. It's not limited to filing practices in any particular districts. Unless someone leaped to the conclusion that this represents a problem for criminal cases alone, it'd be well to take stock of the impact of this really startling explosion on filings on the availability of judge time for all other aspects of the judicial system. As a result of both constitutional and statutory provisions designed to protect the rights of those charged with crimes, criminal cases can't be delayed for lack of available courtroom time like almost every other kind of legal matter can. That may be an unpleasant reality, but it is a reality nevertheless. The immediate and undesirable effect of this surge in criminal demand is therefore to starve virtually every other aspect of the justice system of much needed resources and cause often extremely harmful delay in the resolution of pressing non-criminal problems. The state's replete with examples of chief judges having to reassign their judges that are handling civil cases to handle criminal cases instead. And then districts with, that smaller districts are ones that handle every kind of case in the same courtroom. It's pretty typical now for judges to just have to be spending more of their time on criminal matters, which obviously deprives the civil docket of the time it needs. Just one example, not only are these civil cases being crowded off the docket, but in some places, criminal matters are being handled in ways that impact logistical and security concerns. For example, in Denver, criminal cases are of some kinds, are being regularly handled in courtrooms that would otherwise be devoted to civil matters, despite the fact that those courtrooms operate out of the old city and county building, which lacks the logistical and security advantages for which the new Lindsay Flanagan criminal facility was specifically designed. I think probably everybody would agree, few legal matters are more emotional and anxiety-provoking than family law matters. Family law cases that involve dissolution of marriages, decisions about the custody, parenting time, and financial support of the children, and division of marital property. But quite apart from the breakup of marriages, the plight of abused and dependent and neglected children is one of the most urgent problems needing resolution in the courts. And yet, despite that, delay resulting from a lack of available judge time greatly elevates the anxiety level of both the adults and children in these situations, and prolongs uncertainty concerning the permanency of child placement, arguably reducing the likelihood of satisfactory outcomes for many of those children. If there are any number of examples, I'll just shotgun you with a few of hardships suffered by very ordinary people when they're unable to get a timely resolution of legal matters affecting their lives, their relationships, their property, their finances. Whether the matter needing legal attention is big or small, delay caused by backlog can be terribly significant if you're one of the people involved. Delay caused by backlog and a lack of available judicial decision makers adversely affects not only the contractual arrangements of large commercial enterprises, but of small businesses and consumers as well. Not only property disputes among large corporations involving, for example, valuable mineral rights or water rights, but perhaps even more so among small farmers or homeowners needing some degree of certainty concerning their financial arrangements. Not only the devolution of large estates by wealthy decedents, but also pressing questions of guardianship of the elderly or infirm, and the distribution of even modest assets among the survivors of non-wealthy decedents. And not only wrongful death actions and substantial monetary claims for debilitating personal injuries, but even common insurance disputes over property damage or the medical costs of injuries that are ordinary enough, but nevertheless beyond the means of damaged parties to handle. I said there was really two directions. In addition to the sheer volume, the need for judges and specialized sports staff is also being driven by both the changing nature of the people who are appearing in our courts and the changing role of the judiciary in trying to solve fundamental society problems leading people to wind up in court in the first place. Not so long ago, certainly within my memory, a debate raged in the judicial community about the appropriateness of involving the courts too directly in treatment and rehabilitation. At least in this state, and I believe that argument has pretty much passed. The judicial department in general and the district courts in particular increasingly involved in innovative approaches to dealing with societal problems that go beyond and in fact are often the cause of criminal or other antisocial behavior. Problems like poverty, addiction, mental illness. One specific example I'll give you of an approach that's particularly demanding of judge time is the ever-expanding use of what's now being referred to as problem-solving courts. Problem-solving courts can take on many, many different forms and be directed at a wide variety of social ills, like drug or alcohol dependency courts, or sometimes special classes of defendants, like veterans courts. But the approach they share is a close monitoring with regular reappearances of participating criminal defendants by judicial officers themselves rather than only by probation officers or treatment providers, with the objective of immediate step-by-step increases of rewards and punishments for compliance or noncompliance with judicial directives. The increasing demand for these kinds of courts reflects their success with regard to rehabilitation and reducing recidivism. But in order to be successful, they require extensive courtroom supervision and place additional demands on judge and staff time. While these approaches appear to be extremely beneficial for the individuals involved and for society in general, and they're clearly less costly overall than simply imposing punitive sentences, their immediate impact on judge-intensive supervision and therefore the need for more judges is very great. Even in the more traditional courtroom setting, though, increasing numbers of folks are appearing without legal assistance of any kind, and that's taken a big toll on judge time, as you might guess. Each year now, fully 75% of the parties appearing before judges in domestic relations cases throughout the state are unrepresented, are pro se, are not represented parties. While judges can't act as lawyers for self-represented parties, basic fairness obviously requires more lengthy explanations about the proceedings themselves and about the options available to the parties. And so it greatly slows down the proceedings, even with regard to things that would otherwise seem to be the most perfunctory kind of formalities. The judicial branch continues to work on a number of initiatives with the practicing bar and the other two branches to provide greater access to justice, including the use of what you may have heard we use the term Sherlocks now, meaning self-represented litigant coordinators, which we have in courtrooms throughout the state to assist these pro se or unrepresented people. Finally, let me just say a word or two about the probation department, because it falls in line with these initiatives that we're all working at now to try to find solutions other than incarceration in the Department of Corrections. In line with these initiatives, probation department's being asked to supervise higher and higher risk individuals. It's requiring greater and greater supervision for the protection of the public. Maybe the most important thing, I'll skip some of the numbers about probation, there are a lot, but just one that may strike you as startling is for adults. The figures I get now is the annual cost per person of having someone on probation is about $1,500. Compare that to the annual cost for having someone on parole after having served a prison sentence and being supervised by the parole department is somewhere around $6,000, more like about $9,000 for community corrections programs, and $38,000 for having someone incarcerated in the Department of Corrections. I mention all this because everybody is not aware, it doesn't immediately come to mind to us, that probation is still falls within the supervision of the judicial branch. So you can't just, the executive, the Department of Corrections, can't just shift funds to supervise people in different ways from things that have been allocated to them. The funding for probation comes and has to come through the judicial budget. You know, when I was a young officer in the Army, you'd frequently be teaching soldiers who were out in the field, and they'd have these makeshift bleachers, and everybody knew that if you were so bad you made people fall asleep and fall off the bleacher and injure themselves, that you would be downgraded as an instructor. Okay, so rather than, I can't tell if we're reaching that stage right now, but rather than get close to that, let me just wrap up by saying, if it were not already apparent, let me reemphasize that's just how pleased I am with what I've discovered since taking responsibility for the judicial system of the state. And by the way, just how proud I am of the department. We have, compared to other states, virtually any other states, and we have a really highly skilled, impartial, and dedicated corps of judges in the state who are intent on providing, to the best of their ability and resources, the kind of justice that your constituents, the people of the state, are entitled to. And after spending some time working closely now with the court administrator, Mr. Ryan, I am firmly convinced that he's equally intent upon ensuring that all of those under his supervision do all they can to assist the judges in the state to have sufficient time and resources to perform their core function, again, which is acting as neutral decision makers to resolve the individual cases brought to them by the people of the state. While the burden ultimately falls on you as legislators to wisely allocate the resources of the state, I want to assure you that under my watch, the judiciary will continue to provide you with the most reliable and helpful data we can to assist with that task. After I actually got on the court myself, I got to know more personally one of the justices who had retired, but whom I had practiced in front of almost all of my career. You may remember Justice William Erickson, Bill Erickson. But after I got to know him personally, I found out he just had this really storied career as a trial lawyer, nationally known. And most importantly, from my point of view, he was like a font of good trial stories and judicial lore and humor. And one of the stories I heard him tell, one of the humorous, self-deprecating stories I'd heard him tell a few times, was about a lawyer who argued in front of his state Supreme Court, appeared in front of the state court Supreme Court, wearing a clown costume. And he said, no one said anything during the argument, but later the opinion written by the Supreme Court came out and it went against this lawyer. And the lawyer spotted at some point one of the Supreme Court justices on the street, and he came up to him and he said, "Just tell me truthfully, you ruled against me because of the way I was dressed." And the Supreme Court justice said, "Oh, no matter how offended we were by your conduct, we always decide according to the law." To which the lawyer in Justice Erickson's story responded, "Well, I only asked because I thought that would have been a heck of a lot better reason than any of the ones you gave in your opinion." Since becoming chief, I get asked a lot of times, what are you going to change as chief? What do you want to accomplish? I tell you, we don't have to look for change. Change is coming at us like a locomotive, both you and our branch. I tell them, I want to keep up with the change while I'm in charge of this branch, and I want to leave the branch in as good a shape as it was handed over to me. And that is really with regard to my second hat, the hat as administrator. With regard to my hat as still a judge, a justice, trying to decide individual cases, doing law, what I hope for is to reach retirement without ever having had somebody come up to me on the street and say, "That'd be a heck of a lot better reason than the ones you gave in your opinion." I thank you very much for your attention and especially for the invitation to come today. Thank you.
Thank you, Chief Justice Coates. Will the committee escort the Chief Justice from the chamber? Majority Leader Garnett.
Thank you, Mr. President. I move that the message from the Chief Justice be printed in the House Journal.
If there is no objection, the Chief Justice message will be printed in the House Journal. Majority Leader Fenberg.
Thank you, Mr. President. I move that the joint session be dissolved.
Is there any objection? Seeing none, the motion to dissolve the joint session is adopted.
You did a good job.
Aye.